Very good morning. Welcome to EduSpace channels. Before starting the further part of fundamental right, one small request from you guys. Please like, subscribe on my YouTube EduSpace channels and please press the bell icon in order to stay tuned for what more upcoming video, right? Let's start the what further part of this Indian polity by what M. Laxmikant. I'm discussing from this fourth edition that revised and updated, and here that what I'm going to discuss fundamental right further chapters. Let's switch to fundamental right. Just wait for a moment. Let me open fundamental right chapter. In this chapter, I was discussing right to equality already finished, and this creamy layers already I discussed. Equal opportunity also I discussed. Mandal Commission everything I discussed. Mandal Commission report I discussed. Let's go for fourth part. That nothing but abolition of untouchability, right? Article 17 abolishes untouchability and forbids its practices in any form, right? The enforcement of any law, disability arising out of untouchability shall be an offence punishable in accordance with law. In 1976, the Untouchability Offences Act 1976 Untouchability Offences Act 1955 has been comprehensively amended and renamed as Protection of Civil Rights Act 1955 to enlarge the scope and make penal provisions more stringent. Act defines civil right as any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution, right? The term untouchability has not been defined either in the Constitution or in the Act. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense, but the practice as it has developed historically in the country. It refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain castes. Hence, it does not cover any social boycott of any individuals or their exclusion from the religious services, etc. Under this Protection of Civil Rights Act 1955, the offences committed on the ground of untouchability are punishable either by imprisonment up to 6 months, or by fine up to rupees 500 or both. Right. A person convicted of the offence of untouchability is disqualified for election. A person is having offence of untouchability is disqualified of elections to the parliament and state legislature. Which act I am talking about? I am talking about Protection of Civil Rights Act 1955. In Protection of Civil Rights Act 1955, it deals with that if any persons found that nothing on the ground of offense on the ground of untouchability, they are punishable either by imprisonment up to 6 months or fine up to 500 rupees or both if any persons found guilty under untouchability under the Protection of Civil Rights Act, they are nothing but they will be disqualified for elections to the parliament or state legislature, right? So this act declares the following acts as offense, that nothing but preventing any persons from entering any place of public worship, right? From worshipping therein, right? Justifying untouchability on traditional, religious, philosophical, or other grounds. Denying access to any shop, denying access to any shop, hotels, places of public entertainment, inserting a person's belonging to inserting a person belonging to scheduled caste on the ground of untouchability, refusing admit persons in hospitals, educational institutions, hostels established for the public benefit, preaching preaching untouchability directly or indirectly, refusing to sell goods, right, or service to any persons. That the Supreme Court held that right under right under Article 17 is available against private individuals, that it is constitutional obligations of the state to take necessary action to ensure that this right is not violated. Right? Sorry. Fifth subpart, that nothing but abolition of titles. Right? Article 18 discuss about abolition of titles. Article 18 discuss about abolition of titles. Article 18 discuss about abolition of titles. Right? We should know about how Article 18 discuss about abolition of titles, that you need to know. It abolishes titles and makes four provisions in that regards. What are those four provisions? It prohibits it prohibits the states from conferring any titles except military, academic distinctions on whether citizen or a foreigner, it doesn't matter. Whether citizens or a foreigner doesn't matter, but the Article 18 is applying applied for that what that articles. It prohibits the state from conferring any title except military or academic distinction. It prohibits a citizen of India from accepting any title from any foreign trade. It prohibits a citizen of India from accepting any title from foreign state also. A foreigner holding any office of profit, a foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of president. Without the consent of president, that what, even a foreigner holding any office of profit under the trust and or under the state cannot accept any titles from any foreigners without the consent of president. No citizen or foreigner holding any office of profit under this trust under or trust the state is to accept any president, right? Very good. Means we are talking about the nobility titles. Previously they were given Maharaja title, Raj Bahadur titles, Rai Bahadur titles, where Rai Sahab, Dewan Bahadur title, etc. This thing I am talking about. Article 18. These are against principle of these are against the principle of equal status of all, right? So in 1996, Supreme Court upheld the constitutional validity of the national awards. That's nothing but in 1996, Supreme Court upheld the constitutional validity of the national award, just like what? Which national awards I'm talking about? National award, that nothing but Bharat Ratna, Padma Bhushan, Padma Bhushan, Padma Shri, etc. It ruled that these awards do not amount to titles. These awards do not amount to any titles, right? Meaning Article 18 that prohibits only hereditary titles. That prohibits only hereditary titles of nobility, right? That nothing but son of king is going to get title of king and all those. So this thing getting what? Abolished is prohibited by the getting the hereditary titles of the nobility, right? Therefore, they are not they are not violate of Article 18, and their theory of equality does not mandate that merit should not be recognized. Theory of equality does not mandate that the merit should not be recognized. However, it is ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should forfeit the awards. These national awards are instituted in 1954, that Janta Party government held by Morarji Desai in 1977, but they were again revived in 1980 by Indira Gandhi government, right? Now let's start discussing right to freedom. Next fundamental right to freedom, right? Here, first part of 19 right to freedom, that nothing but protection of six rights. Here I am going to discuss about Article 19. Article 19 guarantee all citizens the six rights. Article 19, if in exam they are going to ask which article guarantees all citizens six rights, that nothing but guarantees to all citizens six rights. These are what? Right to freedom of speech and expression, right to assemble peaceably without arms, right to form associations or unions or cooperative societies, right to move freely throughout territory of India, right to reside and settle in any part of the territory of India, right to practice any profession, right to carry any occupations, right to trade or business throughout the India, right? That's why we are able to do business throughout India, right? Because constitution has given right to profess any profession throughout the India, to carry on any occupation in India, to do any kind of trade or business throughout India, right? Original 9 article 19 contains seven rights, right? But right to acquire, hold, and dispose of property was deleted by 44th Amendment Act of 1976. So here, UPSC they can ask question that Article 19 contains seven rights, but the right to acquire or hold or dispose of property was deleted by which amendment? 44th Amendment Act of 1978. 44th, what it? 44th Amendment Act of 1978. In his previously it was there seven, total seven rights were there, but later that right to property were amended in 44th Amendment Act of 1978. So only six rights remained behind. Six rights were protected against only state actions, not to private individuals, not to private individuals. Moreover, these rights are available only to citizens and to shareholders of a company, but no, not to the foreigners or legal persons like companies or corporations, etc. The state can impose reasonable restrictions on the enjoyment of six rights only to the only on the grounds mentioned in Article 19 itself, and not on any other grounds, right? Next, going to discuss freedom of speech and expressions. Freedom of speech and expressions, it implies that every citizen having right to express his views, right, opinions, beliefs, convictions, even freely by the word of mouth, writing, printing, picturing, any other manners, right? So Supreme Court held that freedom of speech and expression includes the following things. Freedom of speech and expressions includes following things. What are those things? Please understand, please be focused. Right to propagate one's view, right, freedom of press, right, freedom of press is there, freedom of commercial advertisement is there, right against tapping of telephonic conversation also, right to telecast, right, that is the government has no monopoly on electronic media. Government has no monopoly on electronic media. Right against band called political party or organizations declares on band, these are all right. Next, right to know about government activities, right, freedom of silence, right against imposition of pre-censorship on a newspaper, right to demonstration or picking, but not right to strike, right. The state the state can impose reasonable restriction state can impose reasonable restriction on the exercise of the freedom of speech and expressions on the ground of sovereignty and integrity of India, security of a state, friendly relation with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Next is freedom of assembly. Every citizen having right to assemble peacefully without arms, right? It includes right to hold public meetings, demonstrations, take out processions. This freedom can be exercised only on public land. Assembly must be peaceful and unarmed. This provision does not protect violent, disorderly right to assembly or one of the causes breach of public peace or one that involves arms, one that in arms should, involvement should not be there. This right does not include right to strike. It's not like that just we gathered public and we started doing a strike, right? So this does not comes under freedom of assembly. Freedom of assembly say that that nothing but please you do assembly, but the thing that should be a peaceful and unarmed manner, right? A strike should not be there. Does not include a strike, right? Writers assembly should not take place, right? It should not be violent, right? Got the point? Should be free for public peace, right? Public peace without arm, right? These are the keyword you should remember. State can impose reasonable restrictions on the exercise of right of assembly on two grounds. First, that namely sovereignty and integrity of India and public order, including maintenance of traffic in the area concerned. Right. Next, we are discussing about Section 144 of the Criminal Procedure Code (CPC) 1973. In CPC 1973, that nothing but under Article Section 144. This section is very important, right? So, magistrate can restrain an assembly, meeting, or processions if there is a risk of obstruction, annoyance, or danger to human life, health, or safety, or a disturbance of public tranquility, or a right, or any affray. That nothing but we are talking even under section 141 of IPC Indian Penal Code, that assembly of five or more persons becomes unlawful, right? Assembly of that nothing assembly of five or more persons becomes what? Unlawful. So when under article 141 section 140, sorry, not article, under section 141 of Indian Penal Code, that deals with that nothing but assembly of five or more than five persons becomes unlawful, right? Next, that to forcibly occupy property of some persons. It deals with that nothing but to commit any mischievous or criminal trespasses, right? To force some persons to do an illegal act, to threaten the government or its official on exercising lawful powers. Freedom of associations. Next, freedom of associations, right? Nothing but all citizens have the right to form associations or unions or cooperative societies. It includes the right to form political parties, companies, partnerships, firm societies, clubs, organizations, trade unions, or any other any body of persons. It only includes the right to start an associations union, but also to continue with the associations or unions such as further it covers the negative right of negative right of not to form or join an association or union. Reasonable restriction can be imposed on the exercise of this right by state on the ground of sovereignty and integrity of India, public order and morality subject to these restrictions, and citizens have complete liberty to form associations or unions for pursuing lawful objectives and purposes. However, the right to obtain recognition of the association is not a fundamental right. Supreme Court held that trade unions have no guaranteed right to effective bargaining or right to strike, or right to declare a lockout. Right to strike can be controlled by an appropriate industrial law. Right to strike can be controlled by an appropriate industrial law, because industry is that nothing but strike keeps on happening, no? That freedom of movement, this freedom entitles every citizen's freedom of movement, means one place can free to move from one place to other place throughout the India, right? So this freedom entitles every citizen to move freely throughout the territory of country, right? Got it? Very good. Supreme Court held that freedom of movement of the prostitutes can be restricted on the ground of public health and interest of public morals, right? Bombay High Court validated the restriction on movement of persons affected by AIDS. That nothing but High Court validated the restriction of movement of persons affected by AIDS. If any person is that nothing but suffering from AIDS, means uh, they should not move from one place to other place because of spreading of this disease, right? Means restricting the spread of this disease. Freedom of movement has two dimensions, that nothing but internal dimensions, external dimensions. Internal dimensions deals with right to move inside the country. External dimension deals with right to move out of the country and right to come back to the country. Right. Article 19 protects only the first dimensions. Article 19 protects only the first dimension. What first dimension? That nothing internal dimensions. That nothing but right to move inside the country. Right. Second dimension is dealt in Article 21. Second dimension is dealt in Article 21. What are second dimensions? That nothing but Article 21, that right to move out of the country and right to come back to the country, that are right to life and personal liberty. This Article 21, right to, sorry, right to life and personal liberty comes under Article 21. That Article 21 also deals the second dimensions, right? Next is freedom of residence. You can have residence throughout the India, just like you are staying in, you have taken birth in Bihar and you are going to, you are free to uh, have residence in other states also. That nothing but right to reside any part of the country, right to settle in any part of the country. It's not like that taken birth in Bihar and you cannot settle in that what Jharkhand, you cannot settle in New Delhi, you cannot settle in the MP, UP and all, right? You can settle, you are having right, that nothing, you can settle any part of the country. Who has given right? That nothing but that you are the freedom of residency there, no freedom of residency there in the constitution is mentioned, that nothing but you are having right to settle in any part of the country, right? So the thing is that this this right that intended to remove internal barriers. Internal barriers are removed, just like one state barriers should not happen, be there, right? It promotes nationalism, right? Because we all are united. It's not like that people from UP should avoid, that people from Bihar should avoid that what people from Maharashtra. It's not like that. We are all Indians, and nationalism must be, in order to promote the nationalism, that what internal barriers have been removed, right? So think that what even mindedness people, so they are not promoted, right? In order to promote nationalism, that what internal barrier must be removed. State can impose reasonable restrictions on the exercise of a right on two grounds, namely interest of general public, protection of interest of any scheduled tribes, right of outsiders to write and settle in tribal areas is restricted to protect the distinctive culture, language, custom and manners of scheduled tribes, and to safeguard their traditional vocation and properties against exploitations. In many parts of the country, and the tribal have been permitted to regulate their property right in accordance with the customary rules and laws. Supreme Court held certain areas can be banned. Certain areas can be banned for certain kind of person like prostitutes, that nothing but habitual offenders. From the above, it is clear that right to residence and right to move are overlapping. Right to residence and right to movement are overlapping to some extent. Both are complementary to each other. Next is freedom of profession, freedom of profession, etc. Means you can do job in any part of the country, right? All citizens are given right to practice any professions, carry on any occupation, trade or business. Right is very wide and it covers all the meaning of earning one's livelihood. State can impose reasonable restrictions on the exercise of this right in interest of general public. Further, the state is empowered to prescribe professional or technical disqualification necessary for practicing any profession. You can you can carry your profession throughout India, anywhere you can do your trade or business, right? You can that any person can carry by itself any trade, business, industry or services, whether to exclusion complete partial citizens or otherwise. They are talking about right, means there should not be objection when a state carries on trades, business, industry, or service either as monopoly, right? That to the exclusion of citizens or in the competition with any citizens, the state is not required to justify its monopoly, right? This right does not include the right to carry a profession or business or trade occupation that is immoral. Immoral means that we are talking about child trafficking, woman trafficking, right? The or any dangerous things, right? Carrying drugs and all, carrying explosive, right? Doing business, drugs business and all this not allowed, right? Protection. Protection in respect of conviction for offenders. Article 20 deals with it grants Article 20 grants protection against protection against protection against arbitrary and excessive punishment to an accused persons. Article 20 grants protection against arbitrary and excessive punishment to an accused persons, whether citizen or foreigner or legal person like a company or a corporation. It contains three provisions in that direction. It contains three provisions in that direction, that nothing but no ex post facto law, no ex post facto law. Second, no double jeopardy. Third, no self incrimination, no self incrimination. What is no ex post facto law? That no person shall be convicted to any offense except for violation of a law. No person shall be convicted for any offense except for violation of law in force at time of commission of act. Next, subject to penalty greater than the prescribed by law. Subjected to penalty greater than prescribed law in force at the time of commission of the act. No double jeopardy. What is it? No person shall be prosecuted and punished for the same offense, right? If any person is hanged but he didn't die that time, means for one offense that person cannot be punished twice. That is nothing but no double jeopardy. No self-incriminations, that nothing but no person accused for any offense shall be compelled to be a witness against himself. Same persons cannot be compelled to be a witness of himself, right? That got it. Protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to compulsory production of material objects. Compulsion to give thumb impression, specimen signature, blood specimen, and compulsory exhibitions of the body. Further, it extends only to criminal proceedings. and not to the civil proceeding or proceedings which are not of criminal nature. Next, Article 21 deals with protection of life and personal liberty. Article 21 deals with protection of life and personal liberty. Article 21 deals with protection of life and personal liberty. Article 21 deals with protection of life and personal liberty. Article 21 declares that nothing but no person shall be deprived of his life or personal liberty except according to procedure procedure established by law, right? Infamous Gopalan case 1950, that nothing but infamous Gopalan case 1950. These things, these famous case you can quote in what UPSC mains exam, that Supreme Court has taken a narrow interpretation of the Article 21. It held that protection under Article 21 is available only against arbitrary executive actions and not from arbitrary legislative actions. It means that a state can deprive the right to life and personal liberty of a person based on a law. This is because of the expression procedure established by law in Article 21, which is different from the expression due process of law contained in American constitutions. Hence, the validity of a law that has prescribed a procedure cannot be questioned on the ground that law is unreasonable, unfair, or unjust. Secondly, the Supreme Court held that personal liberty means only liberty relating to the persons or body of the individuals. In Menka case, right? In Menka case, Supreme Court overruled its judgment in the Gopalan case, right? Menka case 1978, Supreme Court overruled the judgment of Gopalan case by taking wide interpretation of Article 21. It ruled that right to life and personal liberty of a person can be deprived by law provided procedural pres- prescribed by that law is reasonable, fair, and unjust. In other words, it has introduced the American expressions due process of law. In effect, the protection under Article 21 should be available not only against arbitrary executive action but also against arbitrary legislature action. Further, the court had held that right to life as embodied in Article 21 is not merely confined to animal existence or survival, but it includes within its ambit the right to live within the with human dignity and all those aspects of life which go to make man's life meaningful, complete, and worth living. It also ruled that expression personal liberty in Article 21 is of widest amplitude and it covers a variety of rights that go to constitute the personal liberty of man. Right to life and personal liberty deals with what? Article 21. They discuss other part of Article 21. What rights mentioned in Article 21, that right to live, right to live with human dignity, right to decent environment and protection against hazardous activities, that right to livelihood, right to privacy, right to shelter, right to health, right to free education up to 14 years, right to free legal aid, right against solitary confinement, right to a speedy trial, right to handcuffing, right against inhuman treatment, right against delayed executions, right to travel abroad, right against bonded labor, right against custodial harassment, right to emergency medical aid, right to timely medical treatment, right not to dip driven out of state, right to fair trial, right of prisoner to have necessity of life, right of women to be treated with decency and dignity, right against public hanging, right to hearing, right to information, right to reputation, right? These things comes under what? These all rights comes under Article 20, Article 21, right? Next is right to education. Article 21 declares that a state shall provide free and compulsory education to all children who is below 14 years, means from age 6 to 14 years. They must get what? Compulsory education. Children below 6 to 14 years, they must get compulsory education, right? This provision added in 86 Constitutional Amendment Act of 2002. From here they can ask questions in UPSC prelims, that from which amendment act that this provisions being added, that the education for all, where that 86 Constitutional Amendment Act of 2002. Got it? Even before this amendment, constitutional content provision for free and compulsory educations under Article 45 in Part 4 of the Constitutions, and it was not enforceable by the courts. Now there is scope for judicial intervention in this regard. Article 45 in Directive Principle DPSP, right? Here they discuss that the state shall endeavor to provide early childhood care and education for all children until until they complete the age of 6 years. It also added a new fundamental duty under Article 51A that reads, it shall be the duty of every citizen of India to provide opportunity for education of to his child. Duty of every citizen of India to provide opportunity for education to his child, or what, right? Between 6 to 14 years, means if any child is not getting free education, so if they are not if they are forcing their children to do work instead of learning in the during the age of 6 to 14, means who will be punishable? Obviously the citizen of India to whom that child is belonging, that is responsible, so it must utilize the government schemes, must enjoy the constitutional right, comes under Article 45, right? Very good. In 1993, Supreme Court recognized a fundamental right to primary education in the right to life under Article 21. It held every child or citizen of this country has a right to free education until they complete the age of 14 years. Thereafter, his right to education is subject to the limits of the economic capacity and development of the state. In this judgment, the court overruled its earlier judgment 1992, which declared that there was a fundamental right to education up to any level, including profession, education like medicine and engineering. In Article 21A, Parliament enacted Right of Children to Free and Compulsory Education, that nothing but RTE, Right to Education Act 9, 2009, that this Act 6, Article 21A, I am talking, this Act 6 seeks to provide every children, right, has right to provide full-time elementary education of satisfactory and equitable quality in the formal school which satisfies certain essential norms and standards. This legislation is anchored in the belief that values of equality and social justice and democracy and the creation of a just and human society can be achieved only through provision of inclusive elementary education to all. Protection against arrest and detention. Article 22 grants the protection against arrest and detention. Every citizen is fully protected, right? Instead, they are not doing any crime, right? Criminals, for criminals, that our constitution does not grant It, after doing crime, you can't say that what Article 22 provides here that what protection against arrest and detention, right? So the thing is that what if any person who arrested or detained, detention is of two types. Detention is of two types. So what are those type of detention? Namely punitive and preventive. Punitive detention means to punish a person for an offense committed by him after trial and conviction in the court. Before conviction in the court, or that person cannot be punished, right? Preventive means, on the other hand, detention of a person without trial and conviction by court. Its purpose is not to punish a person for a past offense, but to prevent him from committing an offense in a near future. Its purpose is not to punish a person for a past offense, but to prevent him from committing an offense in the near future. Thus, preventing detention is only a precautionary measures based on suspicion. You might have seen that nothing but police and all keeps on doing lathi charge on this school going children due to some suspicious events, and then what they are telling that what you go, don't repeat that mistake again, don't do this crime again and again, right? What is that? Constitution has given right under Article 22 that under preventive detentions that our police utilize Article 22 and prevent that and just warn criminals, right? But every time they can't go for preventive detention. That's why they sometimes they go for punitive detentions. But the thing is that what is the function of police? Only bringing criminal to the what for the court trial, right? And after court trial, whatever judgment comes, the person gets what being punished, right? Article 22 has two parts. The first part deals with case of ordinary law. First part deals with case of ordinary law. Second part deals with case of preventive detention law. First part of Article 22 deals with the first part of Article 22 deals with the case of ordinary law, and second part of Article 22 deals with case of preventive detention law. Got it? First part Article 22 deals with case of ordinary law, right? So first part of Article 22 confers following right of on a person who is arrested or that demand ordinary law, that nothing but right to informed, right to consult legal practice, right? We contact that what if anybody in a criminal is free to contact defender, right? Advocate and all, right to produce before magistrate within 24 hours, right? Excluding the journey time must be excluded, and within 24 hours, that what that criminal must be produced in front of magistrate, that nothing but magistrate of district, right to be released after 24 hours unless magistrate authorities further detention. Okay, safeguard are not available to an alien persons. Alien persons who is not belonging to India, right? Foreign countries persons. These safeguards is not allowed for alien persons, right? And detained under the preventive detention law. Supreme Court also ruled that arrest and detention first part of Article 22 do not cover arrest under order of court, civil arrest or failure to pay the income tax, deportation to an alien, right? They apply only to an act of criminal and quasi-criminal nature, or we can say some activity prejudicial to public interest, right? The second part of Article 22 grants the person who arrested detained under the preventive detention law this protection available for both citizens as well as aliens, right? So detention of a person cannot be exceed 3 months unless advisory board reports sufficient causes for extended detention. The board is to consist of judges and high court. The board should be consist of judges of high court, and second of this that nothing but ground second the ground of detention should be communicated to the detainee, that nothing but however the facts considered to be against public interest need not be disclosed, that detainee should be afforded an opportunity to make an representation against the detention order. Article 22 also authorizes the parliament to describe the circumstances and the classes of cases in which a person can be detained for more than 3 months under the preventive detention law without obtaining the opinion of an advisory board. Maximum period of a maximum period for which a person can be detained in any classes of cases under the preventive detention law. Third, C1, the procedures to be followed by advisory board in an inquiry, right? So after inquiry, that procedure must be followed, right? 44th Amendment Act of 1978 has reduced the period of detention without obtaining opinion of the advisory board from 3 months to 2 months. However, this provision have not yet been brought into force. Hence, original period of 3 months still continued. Constitution has divided the legislative power with regards to preventive detention between the Parliament and state legislature. Parliament has exclusive authority to make a law of the of preventive detention for reasons connected with defense, foreign affairs, security of India. Both the Parliament as well as state legislature can concurrently make a law of preventive detention for reasons connected with the security of a state and the maintenance of public order and the maintenance of supplies and services essential to the community. The Preventive Detention Law made by Parliament are Preventive Detention Act 1950 that expired in 1969. Next, Maintenance of Internal Security Act MISA, Maintenance of Internal Security Act, right, 1971. This repealed in 1978. Next, Conservation of Foreign Exchange Prevention and Smuggling Activity Act, Conservation of Foreign Exchange Prevention of Smuggling Activity Act, COFEPUSA, Conservation of Foreign Exchange Prevention of Smuggling Activities Act 1974. NASA, National Security Act NASA 1980. Prevention of black marketing and maintenance of supplies of essential commodity act 1980. Prevention of black marketing and maintenance of supplies and essential commodity act, this is what 1980. Terrorist and disruptive activities prevention act, that is called tada code. You might heard in news every time, tada code is what? Terrorist disruptive activities, terrorist disruptive activities, terrorist disruptive activities, tada code, terrorist disruptive activities 1985, repealed in 1995. Sanjay Dutt is being punished under which code? Tada code. He was indulged in what? Terrorist activities. Prevention of illicit traffic in narcotic drugs and psychotropic substance act 1988. Prevention of Terrorism Act POTA, Prevention of Terrorism Act 2002, repealed in 2004. It is unfortunate to know that no democratic country in the world has made preventive detention. No democratic country in the world has made preventive detention as an integral part of the constitutions, right? Whatever done in India. See the liberty of Indian constitutional law, right? They have given preventive detention law. What you understood from this line? Other country that even for a small silly crime, they used to get punished for at higher level. Just think about that, Dubai and all, right? You will come to know. what kind of crime people are doing and what kind of punishment they are doing. So there is no preventive detention law is there, right? It was resorted, right, to the Britain only during First and Second World time. In India, preventive detention law existed even during the British rule. For example, Bengal State Prisoners Regulation of 1818 and Defense of India Act 1939 provided the preventive detention, right? So exploitation, from right against exploitations, I am going to explain in the next video. Please write in the comment section that you are getting benefited from this video series or not. If you want any modifications, if you are having any doubt, then small request from you guys, please comment in the comment sections and please like my Facebook page with the name EduSphere. And one small request from you guys that please 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 requesting you guys, please spread the word of education, right? I'm here to do work for you guys. Like please like, subscribe my YouTube page with the name EduSphere, with the name what? EduSphere channels, and please spread the word of education, right? Me Amit Kumar, also UPSC aspirant. I am doing too much hard work for you guys for providing free educations for those persons who are not getting benefited of these resources. So think that what? Please like, subscribe, comment and share and spread the word of free educations. And if you are having any doubt, you are free to ask question in the comment sections. I will answer your questions within 24 hours, right? It's my personal guarantee. Thanks a lot. Thanks a lot for watching the video, and please subscribe the channel. Subscribe the red button below this video. You can see on the right bottom a subscribe written over there. Please subscribe the channel, like the Facebook page EduSphere. You can see me. You can see me on what Twitter also, right? And you can share this video. I am going to share this video on Google Plus profile also. Everywhere you can search and you can get benefited. Thank you. Bye bye. See you in the next part of this video. Bye bye.